Mistake number 5, there's no wealth transfer strategy. What do I mean by that? Well, first of all, everybody owns something. And we just want to make sure that your wealth transfer strategy and your client's wealth transfer strategy is tailored to the assets that you own. So our real estate developers have very different goals and objectives than our retail clients. And they have very different goals and objectives than our financial advisory clients, and very different goals and objectives to our professional service providers, lawyers, doctors. We represent all industries in various shapes and forms, and there are different assets that can or cannot be transferred depending on the nature of the asset. So we try to develop a wealth transfer plan based on those assets and based on the unique family situations involved. Some families want to pass on their business to the next generation. Sometimes the next generation doesn't want the business or can't handle it. So we engage in management succession planning discussions, wealth transfer planning, and trying to do it at the most efficient, cost-effective manner. A revocable living trust is sort of the basic starting point for wealth transfer planning. It's portable, so if you do one in Virginia, it can be taken to Maryland or California, even if it's properly structured. It's designed to avoid probate, which is really important in all 3 jurisdictions locally. DC has an unsupervised probate statute. Everybody says, oh, probate's not a problem, just do a will in DC. If you've ever dealt with the registers of wills in DC, you will understand that unsupervised probate is worse than anything in Virginia that's supervised because of the people that you have to deal with and the systems and the processes in DC. So avoiding probate is a really special thing. You want to do that. And it's private. It allows us to plan for incapacity as well, as I described. So using the revocable trust as a wealth transfer solution is really important. Again, we all know how revocable living trusts work. The trust maker is the grantor, the creator, the settler of the trust. And if it's your trust, you're the trustee, you're the beneficiary, and you're the creator of the trust. So it's seamless during your lifetime. But the most important aspect of this is, in designing for wealth transfer, is figuring out who's going to control things after you're gone or you're incapacitated. Mistake number 6 is failure to understand and plan for digital assets. Now, there's something called the Uniform Digital Assets Act that is winding its way through various states. It's only been enacted in 1 or 2 states so far, but I suspect in the next 10 years we'll see many more states adopting it. My hope is that all 50 states adopt it, but right now in Virginia, it's not adopted. And so Virginia's statutory requirement is that if you want to have someone gain access to your digital assets, you have to do it in your will. What happens if you become incapacitated? Virginia law is silent on that. But the idea of digital assets, planning for social media, digital assets, what are they? They're financial accounts, online access to anything, email accounts, social media, your Dropbox accounts, your Google Docs accounts. I mean, I have pages of passwords in a very hidden place that gives my successor access to my digital assets. So the first thing you have to do is create a list of all your accounts. And then you have to provide whoever you're entrusting with this with a user ID and password for each account. And by the way, I hope you're not using the same password over and over again for the various digital accounts that you have access to. But in your planning documents, a will in Virginia is effective. We still put directives in our revocable living trusts and our powers of attorney. Will Yahoo still exists, will Yahoo respect the directive in the power of attorney or the revocable living trust? We don't know. We haven't tested it yet here. It's being tested all across the country. There are court cases that started to appear when veterans were passing away and parents were trying to gain access to their email accounts after they had passed away. And there were several cases around the country that dealt with this issue. And each online provider has their own terms of service and rules and regulations. But at least you can advise your clients, hey, are your digital assets accounted for? And have you accounted for them in your estate planning? Mistake number 7, not preserving tax deferral benefit of retirement plans. That was John Denver's big mistake. Most of your retirement account could be accelerated and subject to immediate tax on death unless you take certain precautions. Well, number 1 is naming a beneficiary, designating a beneficiary of the IRA or the 401k. The longer the beneficiary can keep the assets in the IRA after death, the better it is for them if they can afford to do it, because they're stretching it out and they're deferring the income tax consequences over their life expectancy. Yes, sir.
Ryan, would you contrast the idea of naming a beneficiary versus naming your estate as the beneficiary of a qualified plan or an IRA, and what the dangers are of that?
If you name an estate as the beneficiary of an IRA or qualified plan, what happens at that point? Anyone in the room?
Immediately taxable.
Right. It's immediately taxable or payable over 5 years, number 1. Number 2, it has to go through probate. The whole benefit of using a qualified plan or an IRA is that you don't have to go through probate, you can bypass it. Now, some of my clients say to me, wait a second, my kids are going to be maybe 18 or 21. I don't want them to have access to this IRA at the age of 18 or 21. So there are 2 ways of dealing with it. You can have it pass through a revocable living trust, but the revocable living trust needs to be structured so that you can designate a beneficiary and have it stretched over their life expectancy, often referred to as a conduit trust. So the required minimum distribution must be distributed, but it doesn't have to be given to the beneficiary. You can use it for their health, education, maintenance, and support, as long as it's distributed out for their benefit. So you can control it through a revocable living trust. And the second way that we're doing it now is using what we call an IRA legacy trust. So if they don't want to mess around with their revocable trust or have it do anything strange, we can build an IRA retirement trust or a legacy trust, have that trust designated as the beneficiary, and it provides 2 things. 1, it allows the assets to be stretched, but it also provides asset protection. And we believe that it provides protection in the event of bankruptcy. One of the big issues that came up in the last couple of years was a U.S. Supreme Court case called Clark versus Ramekin. And in that case, they ruled that an IRA that's inherited by someone is not subject to the normal bankruptcy protections that IRAs enjoy, because the person who is the beneficiary is not the person who rendered the services who deserved the protection in the first place. That's a very general way of stating what the court found. And so what practitioners have come up with is this IRA retirement trust, which becomes irrevocable at death and therefore becomes, in the form, in some way, an asset protection trust, clear of bankruptcy, as long as you have an independent third-party trustee serving. So we've used these, and they're pretty good. They work pretty well. We haven't had it tested yet. All right, so mistake number 8. And this is to your benefit as a financial planner, financial advisor. It's the failure to organize and consolidate. The estate planning lawyers sometimes try to do this for our clients. We provide tools to the clients to do this. But the financial advisors really are the quarterbacks. The financial planners are the quarterbacks of the estate for the client. They're the ones who know what's going on a daily basis because they're managing the assets. They're managing assets on a daily, weekly, monthly, quarterly basis. They're interfacing with the CPAs on the tax return preparation. They're interfacing with the estate planning lawyers on estate planning structure and vehicles. But consolidating and organizing your assets is absolutely critical. Having it all in one place, some people are skittish about that. Some of my clients have said, why do we have all our eggs in this one basket? What happens if this one basket doesn't perform as well as this other basket? And that's a question that I'll leave to you all to answer for your clients. But I'm a proponent of organizing and consolidating. One, it reduces fees overall, right? And it provides a much more global understanding of what's going on. But a lot of financial advisors will allow for clients to deposit information about their real estate and other business interest investments and other financial investments in a single repository, which I think is a great way of starting to organize and consolidate. What it leads to, the mistake obviously leads to the inability to locate assets. Redundancy in accounts, you'll see 5 different checking savings accounts. Now some of my clients say, well, I'm doing it for FDIC insurance protection. But my response to them is, if you need to have protection for FDIC purposes, we're all in a lot of trouble. Now, it may be logical from the standpoint of one bank being a poor performer versus another bank. So if you have your money in one bank that's giving a good interest rate, but it's insured up to $250,000, then I understand that logic, but it just creates a lot more assets that have to be accounted for in terms of consolidating and organizing. And the idea is just have it all in one place, at least listed. So have a portfolio of your estate planning documents, all the funding that you've done for your estate planning you want in the same place, your deeds, account information changes, gaining access to emergency documents in the cloud or wherever you're going to put them in a secure environment with passwords.